Hey everybody, Stephanie here with the Machine Gun Nest with today's legal update. As I'm sure you've seen by now, there's a lot of talk regarding California's assault weapons ban and that being ruled as unconstitutional. So let's talk a little bit about that.
Last night, a federal judge overturned the ban on assault weapons in California, and the NRA, of course, cheered the decision. In the ruling, Judge Roger Benitez declared the state's 32-year ban violates the Second Amendment's right to bear arms.
The case is Miller v. Bonta, but first, what was or what still is California's assault weapons ban? Well, 32 years ago, California and the Attorney General of California put together this document called the Assault Weapon Identification Guide, and everything that they defined here was no longer legal in the state of California. For example, this is coming from page 81 of that guide. An assault weapon shall also mean the following rifles: a semi-automatic centerfire rifle that has the capacity to accept a detachable magazine and any one of the following: a pistol grip that protrudes conspicuously beneath the action of the weapon, a thumbhole stock, a folding or telescoping stock, a grenade launcher or flare launcher, a flash suppressor, a forward pistol grip, a semi-automatic centerfire rifle that has a fixed magazine with the capacity to accept more than 10 rounds, or a semi-automatic centerfire rifle that has an overall length of less than 30 inches. They also have some more definitions for pistols and shotguns, but this case is primarily dealing with the AR-15. And so what has happened is that Judge Roger T. Benitez ruled this as unconstitutional. And then what happened afterwards, he released a 94-page opinion piece tailored to the common man, tailored in layman's terms for all of us to understand his thoughts behind the case. So he explained that assault weapons are common average guns used in average ways for average purposes. So the state of California was trying to make it sound like assault weapons were these military-grade, specialized weapons that had no business being held in the hands of the everyday citizen. He said that assault weapons is actually a misnomer, and it can equally be called a home defense rifle or an anti-crime rifle, and it's not fair to label it as an assault weapon when it has many other applications. Judge Benitez also said the state should protect against mass shooters, but also should protect against victimization from home invasions and the like. So what's interesting is the precedent from the Heller case. It basically is saying this is a modern rifle commonly owned by law-abiding citizens for lawful purposes. And the AR-15, yes, it is a common rifle owned by the common gun owner for common purposes. And we have a lawful reason to use it in self-defense. And so I love what Judge Benitez said here. He said in 2008, over 900,000 Ford F-150 trucks were sold. And in that same year, 2 AR-15 style rifles were sold per truck. And he was saying that every time you see an F-150 drive down the road, you could know that 2 modern sporting rifles were purchased every time you see that truck. And so there are that many modern sporting rifles out in the country right now, and they are not walking around on their own shooting people. He called the assault weapons ban a continued failed experiment. It does not prevent mass shootings, does not limit attacks on law enforcement. And he said that the evidence reveals that it made no difference in public safety to ban these weapons. Interestingly, California made no effort to find a solution to these problems that did not infringe on people's rights. And so ultimately they decided that the ban doesn't survive constitutional scrutiny. So what does that mean? Does that mean it's now legal in California to go buy these assault weapons as identified in the Assault Weapon Identification Guide? The answer is no. They have 30 days to appeal this case, and funny enough that their 30-day window ends on Independence Day on July 4th. They definitely will be appealing. This will move to the 9th Circuit. And so we're going to wait and see what happens here. But if this does pass, it's going to set an incredible precedent for all of us in other states like here in Maryland, where we might be able to stand a chance to put to bed all of these unlawful rules as well. So we'll let you know what happens after the appeal period, and Firearms Policy Coalition is ready to go to bat to defend this case in the 9th Circuit. We'll let you know what happens. If you liked this video or found it helpful at all, it would help us a lot to like, subscribe, and share.